This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about a company called Velawcity, which allegedly committed Barratry on behalf of lawyers in Texas, and where the court found to be sued for Barratry in Texas, the court must have jurisdiction over the parties. The law in Texas regarding Barratry, an old common law tort, is that a lawyer who pays or gives or offers to pay or give a person money or anything of value to solicit employment for the lawyer commits Barratry. A lawsuit that involved claims for alleged Barratry and conspiracy to commit Barratry filed by the Appellants against the law firm McClenny Mosley Associates, Texas attorneys James McClenny and Zach Mosley, their Louisiana partner, Richard William Huye III, and Appellee Tort Network, PLLC, doing business as Velawcity, an Arizona company that executed several marketing service agreements with the law firm to provide advertising and marketing services. An appeal to the Court of Appeals of Texas involved the trial court's order sustaining Velawcity's special appearance and dismissing the appellant's claims against Velawcity for lack of jurisdiction. In a case entitled Wayne J. Adams et al. Versus the Tort Network, LLC, filed in the Court of Appeals of Texas on March 18, 2025, the Court of Appeal affirmed the trial court's ruling. The appellants, who are Louisiana residents, alleged that following Hurricane Ida, they were solicited through an illegal Barratry scheme that involved Velawcity and the law firm McClenny Mosley Associates, PLLC, better known as MMA. The appellants contended that from December 2021 to August 2022, MMA entered into multiple marketing service agreements with Velawcity to provide marketing services which included pre-screening potential clients for legal claims related to the hurricane. The appellants asserted that these contracts were executed in Texas and that Velawcity acted as an agent for MMA in soliciting clients unlawfully. They are seeking damages for 4 acts of Barratry allegedly committed against each of them, totaling $360,000. The primary issue to the Court of Appeal was whether the Texas courts have personal jurisdiction over Velawcity. The appellants argued that Velawcity has sufficient contacts with Texas due to its contracts with MMA, which they claim involved the solicitation of clients in violation of Texas law. They assert that Velawcity's actions constitute a tort committed in Texas, thus invoking the Texas long-arm statute. In contrast, Velawcity argued that its activities were primarily conducted in Louisiana and that it does not maintain any business presence in Texas, nor did it solicit clients for MMA in Texas. Velawcity filed a special appearance to contest the jurisdiction, asserting that it lacks minimum contacts with Texas necessary for the court to assert jurisdiction. It highlighted that the solicitations occurred in Louisiana and that the appellants are also Louisiana residents. Velawcity emphasized that it had no physical presence or business operations in Texas and that any communications regarding the contracts were not sufficient to establish jurisdiction. The trial court ultimately sustained Velawcity's special appearance, concluding that the appellants failed to demonstrate sufficient context to establish specific jurisdiction in Texas. The court noted that while the contracts were significant, they did not collect Velawcity to Texas in any manner that would justify jurisdiction. The court affirmed the decision to dismiss the claims against Velawcity for lack of jurisdiction, emphasizing that the alleged tortious conduct took place outside Texas and that the appellants did not provide adequate evidence to establish a substantial connection between Velawcity's activities and the operative facts of the case. The appellants' claims against Velawcity were dismissed, leaving them to pursue their case against the other defendants, like MMA and the individual attorneys involved in the alleged Barratry scheme. In my opinion, the suit against Velawcity would have had no jurisdictional difficulty if filed in Louisiana, but the plaintiffs would find no contact with Texas that recognizes a Barratry tort, other than the fact that it signed a contract with MMA, which practices in Texas and Louisiana. MMA has been sued multiple times, is in bankruptcy, and there is supposedly active FBI investigations into criminal conduct by MMA and its lawyers. The plaintiffs, who are residents of Louisiana, can be sued separately in Louisiana courts for their alleged misconduct. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting and access to the more than 5,050 blog postings. You can also subscribe to the videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button for the YouTube viewing and the thumbs up button for rumble.com. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.